This program is brought to you by the Reeves Law Firm, www.reevesfirm.com.
In the know.
Good evening, everyone.
In the know. Tony Reeves. Tony Reeves. Fire. Following the news in any way, shape, or form.
No shortage of things to talk about.
What does it mean? What will it bring?
Is this a reality we simply have to accept?
Tony Reeves. Fire. Tony Reeves.
Let's go ahead and get started.
Why does it take so long to get a decision from a judge or a hearing decision? Okay. First of all, let me just go ahead and start with something that I hope does not offend you, okay? And please don't take this the wrong way, because I know somebody's going to put a comment and say, you know, this guy is a dirtbag. He's always full of crap and he's very unprofessional. You're entitled to your opinion, totally understand, but don't take this the wrong way when I say this. Part of the reasons why I do the videos the way I do is I try my best to be as blunt and straightforward as possible. Your case is not like everybody else's case. So stop comparing yourself to everybody else. And that's the way I say that is this, because if you allow yourself to compare how your case is processed to somebody else's case, you're going to piss yourself off and make yourself stressed. So let's go ahead and start with that fundamental premise. Second of all, let's move to the biggest premise of all. Why does it take so long? To be honest, no one knows. And let me tell you why I say no one knows. Because everybody's case is handled differently. Meaning, you could have the same judge and 5 different people all go before that same judge, and then the person who came there the last may have a decision that's cranked out sooner than the person who was there first. And you're saying that doesn't make any sense. Actually, it makes perfect sense. Everybody's facts are different. Guess what? If the last person the judge saw happened to be someone who had, great medical evidence, they had a bunch of treating doctors who wrote specific limitations about what the person could and couldn't do. There was a lot of evidence to support the claim that the person's disabled, and it was all succinctly put together and presented in such a way that the judge could basically render a fully favorable. That one might not take long to generate. But then you have another one, the first one, where you've got a lot of medical evidence and unfortunately nothing specific about limitations. There's some conflicting information in there. There's some drugs and alcohol issue. There's some issues about conflict, meaning one doctor says one thing, one doctor says another. You got all these things floating around here. Guess what? The judge has got to kind of work all that out and then write that in a decision. And looking at your evidence, the judge may have to decide whether or not he or she wants to send you for an evaluation because everything is not clearly laid out. So as a result, the judge on the first case, which may be 6-7 months older than the case on the last case, 5th case, may have to decide that judge needs to send you to see somebody. Maybe they need some interrogatories done. Maybe they need to ask for you to get some more medical records. And you're thinking, and see, the problem that you run across is that you're thinking in your mind that your file clearly shows you're disabled. A lot of times it really doesn't. So what ends up happening is that the judge is faced with putting the tough situation of trying to figure out what's going on. I've said this to people. I get people call me all the time about different things, and I tell people all the time, you don't want the government trying to figure out if you're disabled. That's why it says you bear the burden of proving. Well, guess what? And see, what the problem that most people run across is they don't have an intimate knowledge. And now, when I say intimate, I want you to understand what I'm saying is. When I say they don't have an intimate knowledge, which means they think they know what the doctor has said, or they looked at the records, they don't have a full appreciation of what the medical evidence says, but they see certain things, like the doctor says I'm disabled, the doctor says this. They focus on the diagnosis and they focus on some of their plans and things the doctor says, but they don't look at the objective stuff. Or they look at it in a bubble. They focus on maybe 1 or 2 things that are great, but they don't think about the 8, 9 things that suck. And you're like, and so that's what I always tell people when they call me. You got one doctor that says you're spectacular. Well, guess what? If you got 8 doctors that say that it sucks, that one doctor is not going to have a lot of weight with the eyes of the judge. And you're thinking, well, that's crap. Actually, no, it's not. That's the law. They have to look at all the evidence as a whole. They can't just sit here and say, we're going to look at this one doctor. He says you're disabled, and we just go boo the other one to the right. No, it's not the way it works. They got to look at everything. So guess what ends up happening? If you got a situation where you got a couple of docs over here to say you're in bad shape, and then another couple of docs say you're not that bad, you got a conflict. And so what happens again is, what did I say? You don't want the government having to figure out if you're disabled. But that's exactly what the judge is doing. So the key becomes is that if the judge is sitting there taking a lot of time, it might be because they're trying to figure out from the evidence you have whether they believe you're disabled or not. The other thing that keeps in mind is you've got to remember if there are warts, and I tell people if there are warts in your case, it's going to take a while. And you're like, what do you mean by warts? Well, if you're not compliant, if the doctors tell you to do something and there's evidence in your file that you don't do it, if you're drugs and alcohol, if there's drugs and alcohol involved, that plays a significant role because you cannot be found disabled if drugs and alcohol are material to your case. Meaning if they think that you're disabled, fine, but then if they take the drugs and alcohol away, they think you're not disabled. They got to determine, okay, well then if that's the case, we got to work this out again. If you got certain conditions that makes things worse because of what you're doing, like what? Well, if you got a breathing condition, but you're smoking a cigarette regularly, you got to kind of take those things out the way. In any event, if you're dealing with someone who is trying to figure out whether or not you're disabled and they're having to decipher things, it can make the process longer. So keep this in mind. And also, sometimes, this is the other thing I want to throw this out there to you, because sometimes people get really frustrated when they hear such and such told me that, they got approved at the hearing. And I tell them, be mindful. Your approval is not final until you get something in writing. Now, they told you what the decision was. Some judges, they have the autonomy to do that, but it doesn't become final until you get it in writing. Are they going to change their mind? I'm not saying that they will. Am I saying it's a possibility? It can happen. It doesn't. I don't know how often it does. I'm not intimately familiar with every jurisdiction throughout the United States, so I don't know when it does happen. I haven't had it happen to me, but I always tell clients, I don't want you to ever get too comfortable until you actually get that thing in your hand and you see it says fully favorable. So long story short, just be mindful of this. The reality is that everybody's case is a little different. Every judge who handles that case is a little different, and everybody's circumstances are a little different. So do not allow yourself to be frustrated when you're trying to figure out why it's taking so long for you to get a hearing decision. Just recognize this, that if that's the necessary beast that you're dealing with, just be patient. And if there's anything you could do along the way, and this is where it's really great. If you're still waiting, don't sit there and wait. Figure out, talk to your rep and say, is there anything I can do to make my case stronger? So if nothing else, I can make it easier for the judge to find them disabled. Trust me when I tell you this, and I'll say this over and over again. You don't want the government having to figure out if you're disabled. You bear the burden of proving you're disabled. Keep that burden going even while you're waiting for a decision.